I have been thinking a lot about what comes next. Dreaming, maybe, about what happens on the other side of, all of this. Religious freedom is a shield. It is a hallowed protection. It is the minority's protection against the tyranny of the majority. And it's a right that is guaranteed by a strong separation of church and state. But we are in the middle of an upheaval. The conservative justices on this US Supreme Court have been weaponizing religious freedom. And I don't say that as a frightful turn of phrase. I mean precisely that. They are turning that shield, that protection, into a weapon that allows the right kind of conservative Christian to impose their religion on others, to violate the rights of other people. And they are actually rewriting the legal meaning of religious freedom as a constitutional right. So the religious freedom that the court has been taking over the past 2 decades, superficially, it's maybe about kids getting skin knees on playgrounds, or veterans, or public education, school vouchers, or crosses, or even coaches that just want to pray. But really, at the heart of every one of those cases, they are about privilege and supremacy. And they're about turning that shield into a sword. And that's the story that I tell in American Crusade, the latest book I have. And I'm not going to retell it here. That was written for a lay audience. But before we kind of get into the fun stuff of rethinking religious freedom, we really have to understand how we got to where we are today. We can't have that conversation, the more fun, imaginative conversation, without realizing how we got to this point today. And how we might then be able to reverse the process. So for my money, the crusade to weaponize religious freedom really kicked off in 2010 with the Salazar versus Bolano case, because the Roberts Court there really signaled a willingness to set aside constitutional principle in favor of Christian privilege. So this case involved an 8-foot-tall cross, Christian cross in the middle of 1.5 million acres of public land. And a retired National Park Service employee challenged that cross as a violation of the Establishment Clause of the First Amendment. Other religions were not allowed to put displays up here. And at the time, there really wasn't a lot of doubt that displays like this were unconstitutional. Throughout the 80s and 90s, the Ninth Circuit had looked at these cases and said, yeah, the cross is the preeminent symbol of Christianity. It's pretty clearly an invocation of Jesus. You can't do it. Kind of keep it to where it belongs, not on government property. The court, in previous cases, called this a simple issue, a straightforward issue, which meant that we were going to be removing those crosses as violations in the name of upholding our constitutional promise. But the remedy was spun as an assault on Christianity, as a threat to Christians, as a loss of their dominant status. And so you have these Christian nationalist groups intervene in this case, groups like First Liberty Institute, to keep the cross up. And eventually the US Congress intervenes also. And so to ensure that this cross stays up, Congress transfers 1 acre of land under that cross out of a sea of 1.5 million acres to a private group. And that private group promised to keep it up. Congress actually retained a reversionary interest if they took the cross down or didn't maintain it. And just to kind of give you a sense of the proportion of that, like that 1 acre out of 1.5 million, if we walk down to Folsom Field, the football field, and put a credit card on the ground there, that would cover more land relative than this. Or it would be kind of like the size of this room right here relative to Boulder. That's what Congress gave away here. And the only purpose behind that giveaway was to keep the Christian cross up. So this is not, it's not a solution to a constitutional violation. It's a constitutional violation itself. And in a 5-4 decision, the conservative justices, so Roberts, Thomas, Scalia, Alito, and Kennedy, on the Roberts Court, they approved this sham remedy. And you can see here from the breakdown that they couldn't really agree on a rationale for approving it, but the end result was the same. All the conservative justices agreed the cross stays up, the land swap is totally okay, and they accept this flimsy legal fiction over a clear constitutional principle to let the Christian cross stay up. And the legal groups on the other side of this case, they heard that message loud and clear. And they begin to file case after case after case in this arena, lawsuit after lawsuit. And this is groups like, you've heard their names now probably, the Alliance Defending Freedom, the American Center for Law and Justice, Liberty Counsel, First Liberty Institute, Becket Fund for Religious Liberty. And their spate of cases accelerates once Trump takes office and begins to change the personnel on the court. And here is what we have seen since the 2010 Cross case, and this is a little depressing, so apologies in advance. In 2011, the court allowed a voucher program to send taxpayer money to private religious schools by denying citizens the ability to challenge that program. In 2012, it said that religious organizations can legally discriminate when hiring clergy, and then it expanded that to employees who have no religious duties, and in 2020, it weaponized that against those employees. In 2014, it said that religious freedom can override the rights of other citizens, and then it upheld Christian-only prayers that the town of Greece was imposing on its citizens. In 2017, the court ignored the religious freedom of all the taxpayers out there and focused just on this one particular church. It was actually a church ministry directed at children, and then it forced Missouri taxpayers to fund that ministry. In 2018, it rediscovered a very potent argument, hostility toward religion. And it used that argument to let a business owner violate the civil rights laws and discriminate against protected classes of people. And then it turned around that same year, 3 weeks later actually, after bemoaning hostility towards Christians in the Masterpiece Cake Shop case, it upheld Donald Trump's Muslim ban. In 2019, it abandoned that need for a sham remedy that they upheld in Salazar versus Buono and just said, yeah, Christian crosses on government property are totally cool and you can spend hundreds of thousands of dollars to maintain them. And then in 2020, it again ignored the religious freedom of citizens and forced them to fund religious schools. And then later that year and into the next is when the court begins striking down public health measures in the name of religious freedom. And just a side note on that, no other First Amendment right successfully strikes down any public health measure during the pandemic. It's only religious freedom that does that, and it's only after Amy Coney Barrett is put onto the court. In 2021, using just a phalanx of legal jargon, and I can already feel myself going off on tangents and getting upset. The court held that religious freedom means that the Catholic Church can discriminate against a minority in the name of God while taking in taxpayer money. And then 2022 was a banner year. Forced the city of Boston to fly the Christian flag over City Hall. That's the same flag that the insurrectionists carried onto the floor of the US Senate on January 6th. Dobbs, I'm sure you all remember that. It upheld an abortion ban that was written by a Christian nationalist group and that had been justified with biblical language. And then it again ignores the religious freedom of taxpayers and forces them to fund religious indoctrination at bigoted Christian schools. And then it ignores the religious freedom of students and families and allows a coach at a public school to impose his personal religion on other people's children. And it just gets worse. The court in 2023, this is the 303 Creative case, it allows a for-profit business to discriminate. This started as a religious freedom case, became a free speech case, and that was the end decision. And you get the point. I'm going to kind of skip ahead because this is depressing. Even up through this term, that last case on there, the Oklahoma case, is really the only time the court has done the right thing, and that was a 4-4 deadlock. This is a case about the nation's first religious public school. Oklahoma created a religious public school. The Oklahoma Supreme Court struck it down as a violation of separation of church and state, and the Supreme Court deadlocked 4-4 only because Amy Coney Barrett had to recuse. That case will be making its way back to the court at some point in a different state where Amy Coney Barrett does not have to recuse. Now, if you have only read the Supreme Court opinions, some of my descriptions probably would trip you up. You might not recognize those cases, but as someone who has been deeply involved in most of these cases, I can tell you that the Supreme Court is not a reliable recounter of facts in these cases, to the point where I really wonder if we live in a shared reality. And I want to give you an example because I know that's a big claim. The Kennedy versus Bremerton case. This is about that public school football coach that was praying with his team. The judges on the Ninth Circuit warned that First Liberty Institute, that's the Christian nationalist group that was behind this case, that the group was spinning a, quote, false and deceitful narrative in the case. Judge Milan Smith, who was a George W. Bush appointee, when he was concurring in the denial of en banc, wrote this. I mean, take a moment to read that because it is pretty remarkable to see language like this in an opinion at the Ninth Circuit. Deceitful narrative, the narrative is false. The reader should know the following basic truth. Kennedy was never disciplined for offering silent private prayers. And Smith even goes through in his opinion and compares the unmoored claims that this Christian nationalist organization is making with what actually happened in the case. That chart goes on for 4 pages. Now, just imagine, right? You guys you've taken MPREs, you got all kinds of fun stuff coming up in your careers. Imagine you are out there litigating a case like this and judges come down and say this about your work. Deceitful, unmoored, false. What do? Like, I would hang my head in shame if this were me. I would maybe take a sabbatical. I would definitely take some ethics classes, right? Instead, they went right to the Supreme Court with that same deceitful narrative. That same chart of unmoored claims, all of it. And just think about that. Think about how confident they were that this deceitful narrative would fall on friendly ears. And the worst part is that they were absolutely right. To the point where Justice Sonia Sotomayor, in her dissent in this case, is so exasperated with the lies that she's just like, look, here are the receipts. Here is him praying with students. And it honestly, it gets worse than this. A full year and a half before First Liberty Institute asked the Supreme Court to take this case, the coach, again, this was near Seattle. This is like the northwest coast. The coach moves to Florida, like the complete opposite corner of the country, and doesn't tell anybody. First Liberty Institute doesn't tell anybody. The courts don't know. Opposing counsel doesn't know. The parties don't know. His only remedy in the case was asking for reinstatement as coach. And before they even took this to the Supreme Court, this guy's going to do a 2,800-mile commute for a $4,500 part-time gig. It is unbelievable. The justices did not have to decide this case. They were aware of this mootness issue at the time and went ahead and decided the case anyway because I think they wanted to. I think they wanted to decide this case. And if you are wondering, did he actually take the job after he won? No, he did not. He went back for one game and then officially quit because of course he did. So how is this possible? Right? How is a case like this possible? And the answer is because our Supreme Court is captured. The conservative legal movement in this country played a long game to pack the courts, and it worked. Leonard Leo is kind of universally recognized as the guy who orchestrated this hostile takeover of the court. And this is what a former employee of Leo's said about this idea that they have successfully made happen. Leo figured out 20 years ago that conservatives had lost the culture war. Abortion, gay rights, contraception. Conservatives didn't have a chance if public opinion prevailed, so they needed to stack the courts. And that's what they did. And I mean, pay attention to the confession in there, right? If we don't stack the courts, democracy is going to work. And Leo orchestrated this capture. Another employee described his job when it came to the judicial nomination process as the monitor of the nominee's ideological purity. That was what Leonard Leo was doing. He wrote the short list of potential Supreme Court nominees that Trump publicized. And all told, he is basically responsible for putting Roberts, Alito, Gorsuch, Kavanaugh, and Barrett on the court. Thomas is an old friend of his. After my book came out, there's actually a video that dropped of Thomas and Leo on stage at a Federalist Society event in Texas together. And Thomas is joking about how Leo is the third most powerful man in the country. And I need to drive this point home, so I'm just going to put it another way, because overall, we have been able to track $580 million that Leonard Leo's groups spent packing the courts. So that's from 2014, blocking Merrick Garland from getting on the court, to 2020, getting Amy Coney Barrett on the court. $580 million. You do not spend that kind of money to put impartial jurists on the court. They bought a court. They bought one entire branch of our federal government. And they bought wins, and it worked. Several studies have actually crunched the numbers, and the data here only goes up through July 2020. I'm talking with the professors who did it and trying to get them to update it. So the numbers are actually significantly more dramatic, because if you remember that list that I showed you, the right-hand column, none of those cases are included in this data. Before the courts were packed, religion was ruled in favor of about half the time, right? About 50%. Those are the first three pairs of columns there. But under Roberts, that win rate jumps to 81%. And this is not a pro-religion shift. This is a pro-Christian shift, right? Think back to the Masterpiece Cake Shop case and the Muslim ban that I mentioned. That pair of cases exemplifies this. Christians won before the court about 44% of the time in cases before the Roberts court. It's up to 85% now. And my back of the envelope calculations for what the numbers will look like when they're updated are 91% and 95%. I don't know how accurate those are, we'll find out. And I just want to pause here, because I know it sounds like I'm angry, and I am, to be honest. And like I'm also attacking this institution. One of my favorite writers of all time is James Baldwin, and he said, "I love America more than any other country in the world, and exactly for this reason, I insist on the right to criticize her perpetually." And that is how I feel about our Constitution and the Supreme Court as an institution. And I refuse to sit quietly in a corner and just accept that our court has been captured. You know, once upon a time, there was a division of the Department of Interior known as the Minerals Management Service, MMS. And it was charged with overseeing all the offshore oil drilling and some other things. But this meant it had to work closely with big oil. And it was an organization that was just riddled with scandal. You know, all the colorful stuff like cocaine and sex with subordinates and sex with oil executives, but also rigging contracts, accepting money and gifts and bribes from big oil, and exempting these drillers from basically every regulation that was out there. And this led to the worst oil spill in history. 200 million plus gallons, the Deepwater Horizon oil spill in the Gulf of Mexico. And a regulatory agency was captured by the industry it was supposed to be regulating. And after that, Deepwater Horizon Minerals Management Service was abolished and retooled, and its sort of duties were redistributed and restructured. We kind of started from scratch. And this Supreme Court is having a judicial Deepwater Horizon every term. And the institutionalist position is we should have an apolitical court, absolutely. But that tanker has sailed, right? It is not happening. So in my mind, the institutionalist position, people who want to protect the court as an institution, cannot pretend that this is business as usual. The institutionalist position is to recognize the court has been captured and try to do something about it. And I also think we're setting a very dangerous precedent if we let special interests spend $500 million capturing a branch of our government and then reaping all of those benefits. I don't think you should be allowed to do that. So that is how we got here. A captured court would be the shorter way to say everything I just said. So what happens next? Because, I mean, maybe we're stuck here. You know, maybe the era of civil rights, Deep and I were talking about this at dinner last night, maybe that era is the aberration, right? I mean, the court is a conservative institution. Maybe it's simply reverting to its conservative mean. But maybe the fever will break. Maybe this too will pass. You know, maybe we'll look at the John Roberts Court as kind of another Lochner era. Maybe one big case after 30 years can save us. Maybe we can get back to some sort of reasonable understanding of religious freedom. And so I'm going to suggest a few ideas about how we might get there. And this is the thinking out loud part where I really would like to hear you. And the first thing that I think we have to do is we have to rethink and expand our understanding of the separation of church and state well beyond the Establishment Clause. Over the last 50 years, the sole functional text relating to church-state separation has been whittled down to just the Establishment Clause of the First Amendment. But that is not where the separation of church and state lies. The separation of church and state, it's much bigger than those 10 words. It is woven into the fabric of our Constitution. So we really need to expand our thinking. And if you look at the Constitution and what it did at the time, it does some terrible things. There are parts of it that are really just not good. But the truly unique and original elements of our Constitution are those that are secular. Right? It begins, "we the people," and those words are poetic, and we've not lived up to the aspiration, but they're also a lot more than poetic. They are a declaration of power. Our Constitution was the first in the history of the world to declare that power comes from people, the governed, not from a deity. And self-government may even be, impossible if power is flowing from the divine, but it is natural when power is flowing from the governed. And our Constitution was the first governing document not to mention a god or a deity. And it's godless by choice, not by accident. And there were a lot of people in the founding generation who were pissed off about that. And the founders chose to do it anyway. And there have actually been a number of movements over the years to rewrite the preamble of the Constitution to add Jesus Christ into it. And every time, those movements have failed. Our Constitution was the first to ban religious tests for public office. That's in Article 6. And this is actually the only mention of religion in the original unamended document. Right? And you all know the Constitution's got a lot of vague language. That's why you are going to have jobs in the future. Right? But this particular piece of text is not vague at all. No religious test shall ever be required as a qualification to any office or public trust. No, shall, ever, any. This is very, very clear, emphatic commands. Justice Story in his commentaries tells us that this clause, this one here, had a higher object: to cut off forever any pretense of any alliance between church and state in the national government. But all of that was still not enough. They wanted more. And so they gave us the First Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and petition their government for a redress of grievances. And those 6 rights, secular government, religious freedom, speech, press, assembly, petition, all of those are meant to bolster your right to think freely, to give you the freedom of thought, to believe freely. So we need to stop thinking about church and state, the separation of church and state in particular, as one minor part of one clause in our Constitution. And as this principle has been whittled down to those first few words and kind of made into this bite-sized tidbit, it was then swallowed, to borrow Justice Sonia Sotomayor's dissent in Carson versus Macon, where this is 3.5 years ago that she's writing this. And she's looking back on a case from 2017. What a difference 5 years makes. In 2017, I feared the court was leading us to a place where separation of church and state is a constitutional slogan, not a constitutional commitment. Today, the court leads us to a place where the separation of church and state becomes a constitutional violation. Again, 3.5 years ago, she's writing this. The conservative majority shrunk the Establishment Clause down to this little dot, and then it sent the free exercise clause after it like Pac-Man. And the better analogy might honestly be that the free exercise clause is now something of a black hole, swallowing other parts of the Constitution and other rights. Look at the language again, because you gotta pause and really appreciate where we are. The conservative justices on the court, who profess themselves to be originalists and textualists, have arrived at this absurd singularity where one 16-word clause is treated as two clauses at war with each other. An amendment at war with itself, a house divided. We are supposed to believe that that comma right there is a declaration of war. That this part of the sentence is hostile to that part of the sentence. And I mean, if you look at this from any kind of detached view, it just cannot be right. It simply cannot be right. But this is how the textualists have interpreted the text. And this is also why I think people hate lawyers. Like the idea that this part of the sentence is hostile to the other part, it makes no sense. And if, by the way, if this text is at war with itself, the Establishment Clause is the one that should win out. So put your textualist hats on, because the religion clauses, they are a ban, shall make no law, on government action. These are things the government cannot do. The first prohibition is broader, meaning the government must do less. The second prohibition is significantly narrower, meaning the government can do more. Free exercise can be burdened, encumbered, hampered, impeded, strained, obstructed. It just cannot be prohibited. Put another way, the text says that free exercise of religion can be regulated, it just can't be prohibited. Meanwhile, the Establishment Clause does not only apply to religious establishments, but, like an official state church, which is what you hear often, but to any law respecting any establishment of religion. That's a much wider swath of what is prohibited. So textually speaking, if these clauses are indeed in conflict, it's the Establishment Clause that ought to win out and trump the others. So that's one area where I'm doing thinking. Would love to hear y'all's thoughts on. The second is, beyond expanding church-state separation, we have to really narrow the free exercise of religion. Professor Micah Schwartzman once dryly observed that at the bottom of every slippery slope involving religious liberty is human sacrifice. And it's a really useful hypothetical. The founders did it, the Supreme Court did it. And the reason that human sacrifice is useful here is because it is the easiest way to distinguish between action and belief. Your right to believe is absolute. Your right to act on that belief is not. And I actually open American Crusade with several stories about people who let Jesus take the wheel. They literally gave control of their vehicle over to their God. A lot of people got hurt in some of these. Sometimes it was more amusing where like one guy drove a Ferrari off a pier, which I was kind of okay with. But, they're free to believe that Jesus is taking the wheel. But the government can step in and act. Give them a ticket, take away their license, all kinds of things. And none of the religious freedom groups out there, by the way, are arguing any differently. And that's because belief is unlimited, but action is not. And if the government can regulate action, as these obvious examples tell us, then, and really as the text of that we just went over tell us, when is it permissible then for the government to step in? That's the next question. And I think the answer there is actually pretty easy too. At the very least, the government can step in where the rights of other people begin. Right? So your right to exercise your religion ends where the rights of other people begin. You all by now have heard the right to swing your nose ends at the other person's, same thing. Right to swing your fist ends at the other person's nose, same thing. So this rule, I think, actually answers many of the questions in the cases that the Supreme Court has been deciding. So, if an owner of a limited liability corporation wants that business to discriminate against LGBTQ people, which would be in violation of state civil rights laws, because of something his holy book says, no, you don't get to do that because your religious freedom is not a right to violate the rights of other people, to harm them. So the Hobby Lobby case, the 303 Creative case, and others would fall in here. The public health cases would fall in here, right? You are your religious freedom is not a license to risk the health and safety of an entire community. The cases where religious nonprofits want to provide government services using taxpayer funds while discriminating, all those fall in here. So again, your religion is not a license to discriminate. And there's another, I think, way to think about religious freedom here, and that's with burdens. And so I don't mean burdens of proof or burdens of persuasion. I mean, who is bearing the burden of somebody's religious belief? And is that person trying to use the law or the government or some other mechanism to shift the burden of religious belief from themselves to somebody else? So in the Hobby Lobby case, the owners of Hobby Lobby, the Green family, were using corporate law and structure to shift the burden of their religion onto employees of that company. Or think about Kim Davis, the county clerk in Kentucky, who didn't want to issue a marriage license, right? Citing her religious beliefs. She is shifting the burden of that belief, the cost of that belief, onto LGBTQ couples. And look, having personal convictions is not easy. And having the courage of those convictions is supposed to be hard. That's why we talk about it as courage. It's up to the believer to shoulder their personal religious burdens, not up to the law to shift it onto other people. And this is where I think it gets, this is maybe the spiciest thing I'll say. If courts are going to allow the religious beliefs of some to harm the rights of other people, or allow believers to shift the burdens of their religion onto other folks, then the courts also are going to have to start examining the truth of those religious beliefs. Right? And this is a taboo right now. This is not something that our courts do. They do not examine the truth of a religious belief. In sincerity sometimes, but that makes sense only when your rights are not affecting other people. If your rights are beginning to affect others, if they're harming others, that taboo has got to fall. And the third thing that I think we need to do here is to resurrect the idea of a government of limited powers. In the age of an authoritarian presidency, it's, I think, particularly useful to rethink power and the limited powers that we've given our government. But I've thought about this in the arena of church and state for a while, because over the last few decades, the courts have been kind of muddling around on like the continuum of coercion. And when are we coercing people into religious belief or religious exercise and not? And kind of one end of the spectrum is sort of like this clearly forbidden, right? Things that don't really happen anymore, torturing people, killing people because of their religion. Though that happened across large swaths of human history and was certainly a reason that we had a separation of church and state. On the other end, though, is maybe those kids at that football game, right? Who feel like they have to pray to play when their coach is telling them, hey, we're going to have a kneel in prayer to Jesus at the 50-yard line. But I think we may be looking in the wrong place when we're thinking about coercion. It's not about the pressure or coercion that people feel from the government. Instead, it's about government officials exercising that power in the first place. That's the problem. And limiting the power of those who hold government offices. I mean, this was a task that it consumed much of what was happening at the Constitutional Convention, right? The separation of powers into three branches is an example of this. The term limits, impeachment, later the Bill of Rights. There's so much of this was spent trying to limit the powers of these people who are holding office. And I think that makes sense because everybody who holds office is flawed, fallible people. And one of my favorite quotes from the founding comes from the Federalist 69. Alexander Hamilton is explaining the king compared to the president. Unlike the king of Great Britain, right, the president has much more limited powers. And he drives home his final point with an exclamation point, which you don't often see. But he says that the one has no particle of spiritual jurisdiction, right? The president has no particle of spiritual jurisdiction. The other is the supreme head of the national church. No particle of spiritual jurisdiction. We the people did not give any government official power over our religious beliefs or over religion generally. And honestly, nor could we. And I think recognizing this is going to be maybe the hardest one especially given the expansion of presidential power that we are seeing. But there is maybe a slightly different way that we can get at this, and maybe one that ties kind of everything I've been thinking about together. And that is that judges must really think about the religious freedom of other people in these cases. And this is something that you just do not see this court doing at all. A good example of this would be in the taxing cases, where the government is taxing citizens and then turning around and giving that money to, for instance, Christian schools. And they're doing it in the name of religious freedom for that school, but they are ignoring the religious freedom of everybody else out there, all the taxpayers. And Thomas Jefferson wrote in the Virginia Statute on Religious Freedom, which James Madison ushered through the Virginia legislature and has really influenced our understanding of the separation of church and state, that to compel a man to furnish contributions of money for the propagations of opinion which he disbelieves is sinful and tyrannical. They were talking about a 3-penny tax, 3 pennies, that would go to support Christian preachers. And that was sinful and tyrannical to them. Compelled support of religion is tyranny, is another way to say that. So no citizen can have religious freedom when the government can force Muslims to bankroll temples, or compel Jews to subsidize Christian churches, or force Christians to subsidize mosques, or to support atheists like myself to any of those. And the Roberts Court has declared this principle as hostile to religious freedom. And the way that it has done that is by focusing only on the religious freedom of the organizations that bring these cases, and ignoring, for instance, in the coach praying case, the religious freedom of all of those kids who are out there on the field feeling pressured to pray. And this could be, I think, pretty easily corrected by looking at that religious freedom. So I'm going to end just by saying that the separation of church and state, it is the basis of freedom of thought. It is the basis from which so many of the other American values that we hold dear flow. It is, I think, the bedrock of true equality, because if the government can force or even recommend that I support a religion, whether with currency or fealty, then I have been made lesser, and adherents of that religion have been elevated. I think it's the basis for the American ideal of self-government. And the wall of separation between church and state, it is an American original. Right? This is an American invention. Until the American experiment, no other nation in the history of the world had tried to do something like this. And I think that that is something that we can genuinely be proud of. And I don't think that we should let a captured court destroy that principle. And I'm going to say that I think it's up to the next generation of lawyers and judges to defend it and reclaim that founding principle. Thank you.